to his order denying the motion for summary judgment. I think you'll see trial judges, as a result, pay a lot more attention to motions for summary judgment, because the first thing it's going to do is it's going to set that motion for summary judgment up for a writ. The trial judge comes back and specifies a very certain reason, very specific reason as to why he's denying it. It's much easier to take it up rather than that general denial that we used to get before. Second good result that we will get as a result of that is I think you'll find a lot more motions for summary judgment granted rather than denied simply because a factual issue existed. Moving on now into the new trial section of our materials on page 67. The first case we'll deal with is Maple versus Cincinnati, and that deals with the issue of when the trial court can delve into the jurors' thought processes in ordering a new trial. In this case, the losing party filed a couple of affidavits from jurors indicating that there was some wrongdoing on behalf of the jury in bringing back its verdict. The trial court, upon seeing the affidavits from the jurors, ordered 11 of the jurors into court to testify on whether there was any wrongdoing in the jury room. There was evidence presented at that mini evidentiary hearing in which the jurors testified that one of the jurers had said that the trial was a waste of time and that other jurors had discussed similar injuries of friends and relatives in this personal injury case. The Court of Appeal found that, first of all, there was no right by the trial court to haul the jurors back before the court to have them testify on this matter. The only way that you can attack that verdict is by affidavits or declarations from the jurors, but you can't subject the jurors to that type of process where they're hauled back before the trial court judge, examined and cross-examined by the counsel in the case. The other issue that the court deals with in the Maple case is whether or not there was actually an inquiry into the mental processes of the jurors as apart from what they did in reaching their verdict. Not their thought processes, but what they did and said to each other. The court said that their discussion of that the trial was a waste of time and that their discussions of similar injuries of friends and relatives was an inquiry into their mental processes. And I don't quite agree with the court, because it seems to me that that's what the jury was doing, and it was not an inquiry into what was behind what they were doing, that is, their mental processes. But the court says, we find that's an inquiry into mental processes. That's not allowed. We cannot set this jury verdict aside on the grounds entertained by the trial court. The next case I want to mention is the Aguirre case. Sanchez-Correa, which is on page 67. That case deals with the Bank of America and another losing proposition and a long line of losses for the Bank of America, both in the stock market and in court. In this case, the poor Bank of America had a $2.1 million jury verdict returned against it. They then convinced, on the motion for new trial, convinced the trial court judge that he should set the entire thing aside. Great, hallelujah. It looked like they were home free. They'd get at least a retrial on the issue. The judge, during the 60-day period in which he had to specify the reason for granting the motion for new trial, only said specifications to follow. He, after the 60 days, set forth these specifications. The Supreme Court reversed the granting of a new trial on the grounds that the trial court had not set forth its specific reasons for granting the motion for new trial within the 60 days, therefore reinstating the jury verdict, therefore allowing judgment to be entered against the Bank of America, even though the trial court judge thought there was grounds to set it aside. The learning of the case is, if you're that losing party and you want to get that motion for new trial heard and upheld, what you have to do is to move the trial court judge along to specify his reasons within that 60-day period. How you do that is another matter, however, because you cannot write the opinion or decision for him. He has to do that himself. And all you can really do is to communicate with him through letters and through communications in which the other party is present, in which you ask the judge to make sure that before the 60 days run, he actually does specify the reason for granting the motion for new trial. The next case I'd like to talk about is Trammell versus McDonnell Douglas Corp., and it's listed on your materials as item number 33. That case deals with the proposition, with the issue of what kind of specificity must be in that new trial order. And in this case, the court was very clear in setting the standard. It said the specifications for a new trial order must make the record sufficiently precise to permit meaningful review, and the specifications must not simply be couched in the forms of conclusions or statements of ultimate facts. So we're harkening back to really that same standard that we had for denial of a motion for summary judgment, and that is the court has to link up the factual issue with the legal issue to tell why the motion for new trial has been granted, as with the prior specificity with respect to the with the denying of the motion for summary judgment. That same interrelationship between the facts and the law has to be stated by the trial court judge.
The attorney section in your materials is once again a variety pack this year. We have the Kumis decision. We have a significant legal malpractice case. We've got a couple of cases on attorney's fees. And then we have a number of cases on CCP section 128.5, the dirty trick section. Let's start with the Kumis decision. It's mentioned in an article on page 25 of your materials. And up to this date, if someone has walked up to you and asked you whether or not you're Kumis counsel and you didn't know what they were talking about and wanted to know whether or not it was a disease or something like that, we're here to provide you relief from that. The name of the case is San Diego Navy Federal Credit Union versus Kumis Insurance Society, and that's where the term Kumis counsel comes from. The holding of the case is rather simple. It's a blockbuster for people who practice in the insurance defense industry, and it basically holds that the lawyers hired by the insurer, if there is a conflict between the insured and the insurer, have to apprise the insured of the right to retain, has to apprise the insured of the conflict, and if the insured doesn't sign off on that conflict, then the insured has the right to choose counsel of its own choice, and the insurer must pay for that counsel. That's the obligation of the counsel hired by the insurer, to apprise the insured of the right to independent counsel. The reason why the Kumis decision was such a blockbuster is because the conflict involved in Kumis was punitive damages. That very often is contained in every complaint we see nowadays. So it calls into question the right of the insured to select counsel. Very controversial decision. There is even talk at the legislature to set it aside by the means of a statute. The Bogart decision on page 73 is really an outgrowth of Kumis. That's a situation where the insurer thought there was a conflict, there wasn't a conflict, and the court held that even if you're wrong, the carrier still has to pay for independent counsel. Moving into the area of legal malpractice, in 1985, the Supreme Court decided Alloy versus Mass on page 74 of your material. I always thought that you analyzed the legal malpractice question case by asking two questions. Is there error first? And that is legal error. And if there is error, then you move on to the question of whether or not that error was negligent. Let's take a look at it as it applies to Alloy versus Mass, which is the continuing saga of the federal military pension. This case falls in between the Supreme Court Smith versus Lewis case and the Court of Appeal Davis versus Damrell case. In Smith versus Lewis, the lawyer didn't research the law and gave an opinion that was incorrect and failed to research the law. In Davis versus Damrell, the lawyer researched the law and gave an opinion that was incorrect. One in Smith versus Lewis, the lawyer was found liable, and the other in Davis versus Damrell, the lawyer wasn't found liable. This case falls within the middle of these two cases. In Alloy versus Mass, the lawyer was relying upon a 1941 decision that held it was separate property, and the court found that that was not enough. Apparently what the Supreme Court is saying in this area is if you analyze it by whether or not there's an error, and if so, was it negligent, the first issue is that the lawyer was ultimately correct. It was a correct interpretation of the law. The lawyer held it was a separate property issue. Well, it then went to our California Supreme Court, and they said it was community property, and it bounced to the U.S. Supreme Court and said, nope, California Supreme Court was wrong. It's separate property. So under the two-prong test, the lawyer was correct. But the Supreme Court still said there was an issue of the lawyer's liability here, and apparently what the Supreme Court is saying is that we as lawyers find the law the way it is, and if it can be used in a certain form, that's to the benefit of our clients, even though it's wrong, you ought to assert it. You may